Good morning, everybody. This is News Now Wyoming, bringing you the follow-up, the response in Miller versus the Stupid Cops. So this is the case there in San Angelo, where the cops arrested a man in Walmart with his son for failure to ID. They stopped him because they received an anonymous complaint from a citizen that did not stick around to be heard, that he was being drunk and belligerent and bullying, and he had a kid with him. So those are the allegations that they went in there with. Walmart employees knew nothing about this, any of this going on. So there was nothing to base it off of other than this anonymous phone call. They arrested him for failure to ID. No other crime. So here we're going to go over their response, and then we'll look at the case law to see if what they say later on in the response is true or not. Okay, so you'll see that they do admit a bunch of stuff, and then they just deny stuff. They admit that it happened. Okay. They admit that his son was with them. They admit the body cam was worn. They admit he was contacted at the checkout line, and that his son was in the shopping cart and there were items in Mr. Miller's shopping cart. He asked if he had been drinking and explained that the police had received a report of an intoxicated driver who had a child in the vehicle with him. They admit he was asked if he knew anything about the report, and he admits Mr. Miller told the officers he thinks someone made a false report. He asked for his name. His name was Jack, but he refused to give his last name. He asked to see the identification, and he had his identification, but refused to show it to officers. Mr. Miller stated he did not have to give them his identification, which is true. So admit a bunch, deny a bunch. Defense admit that Francis and Mayberry told Sergeant Holt later that Miller was not arrested for an offense other than failure to identify. Defendants admit that Miller's stated failure to identify only applied if he had been arrested. So they are admitting that the law is actually what it is, and that they can't arrest him for failure to ID if he wasn't already arrested for another crime. This is a huge, let me just highlight that, because this is a huge admission there. And we'll talk about the case law on that. They admit that his son was present, and that he turned around and was handcuffed. Miss Weber told Miller to put his hands behind his back, and they deny the rest of the allegations. Made the statement, "Look what we're doing, man." Admit DM was present. Deny any remaining allegations. Defendants admit Miller asked, "What are you doing?" Admit Weber made the statement, "We have one resisting." So the officers clearly in the video say one is resisting over the radio. He was pushed against a drink cooler, and they deny how forceful that Mr. Miller says that they were, but the video is very clear on it. They told him to calm down. He was pretty calm. So they deny a crap ton of allegations. Admit Miller asked where his son was, and then defense lacked knowledge or information. So this is probably stuff about the kid's child's welfare after the fact, that he won't go back to the store, etc., etc. Conclusion of law. Oh, paragraph 97 here. As conclusion of law does not require an admission or denial. However, defendants admit that it was clearly established on the date of arrest that a lawful arrest under the Fourth Amendment requires probable cause. So the fact that they are admitting that, okay, says We know that this was clearly established, that you have to have probable cause to arrest somebody for violating a law. Okay? It is a conclusion of law and does not require an admission or denial. However, defendants admit that the offense for failure to identify under Texas Penal Code 3802 can only be committed if a person fails to identify himself after an arrest. So, you can't be arrested solely for failure to identify. You have to be arrested for another crime. So you have to have been arrested for hitting somebody or something, and then failure to ID. It's a conclusion of law and does not require an admission or denial. However, defendants admit that courts view the totality of the circumstances surrounding an arrest in determining whether probable cause for the arrest existed. Here, there was none. They don't even allege any here. They admit he was arrested. So he was arrested. It's not going to be a he said, she said. No, he was detained for questioning for further investigation. That's what a lot of cops try to do. No, he wasn't arrested. Even when they flat out say you are under arrest, they still try to argue in court that the person wasn't actually under arrest, even though they use those words. He was just detained for a short time so they can investigate. Here, they're not going to try to do that. They're going... Okay, so kudos to the attorney. Defendants admit that 3802 is quoted correctly and that Miller was not under arrest at the time he initially failed to identify himself. Deny allegations. Admit Miller brings us under 1983 as alleged, but deny his claims have merit or that he is entitled to relief thereunder. So a bunch more denials or non-denials or admissions. It's conclusion of law, but deny he was imprisoned. So they admit that he was arrested, but deny that he was imprisoned. That is a that is very determinate, case specific. However, the Supreme Court has held that by you being arrested without a warrant, that is an imprisonment. It can be for 5 minutes. It is an imprisonment. Okay? If you are put in the back of a police car in handcuffs while you are under arrest, that is an imprisonment. Massive. Okay. Is Hughes quoted correctly in that Miller was not under arrest at the time he initially failed to identify himself? They deny the remaining allegations. Does not deny. Admit DM was at the scene. Does not require admission. Deny. But deny plaintiff is entitled to any other recovery requested in paragraph 168. He is seeking recovery of attorney fees, but deny plaintiff is entitled to the recovery requested in 169. Does not require admission or denial. Has failed to state a claim for which relief can be granted. False. 1983 is very clear on when you can sue for violations. Now, the Supreme Court has made up rules about, are these rules clearly established? Was this a violation of a clearly established right? That's very important, right? Plead that they are protected by qualified immunity under federal law. That's because of the Supreme Court saying they have qualified immunity if they if they had no reasonable officer would know that they were in violation of a constitutional right. Clearly established. How long has this been known that this is the law? How long has it been known that arresting somebody for not being without probable cause, is that clearly established law? Can you just arrest somebody without probable cause? Is that established law? If that is established law, okay, that you can't just arrest anybody without probable cause, then was there probable cause? In here, was it probable cause for 3802 to apply for an arrest? And up above, they admit that it was clearly established that you can't arrest somebody for that. So I don't see how they can even try to claim qualified immunity, and this is going to require a actual hearing to discuss it. They are protected by official immunity under state law. Wrong, because again, that is state law. Official immunity is for if you again just violate something that you didn't know. You couldn't have known that this was actually a violation. So I can't even think of too many times where clearly established is one aspect of qualified immunity. Official immunity is less stringent than qualified immunity. Qualified immunity requires a court order, under most circumstances, a court to say this behavior was bad by the police, therefore in the future this will not be acceptable. That's what clearly establishes. Official immunity is less strict than that, and this is under the state law of Texas. Through the jurisdictional defense of governmental immunity as to all state law claims because their actions as police officers were done in their official capacity in the course and scope of their employment as police officers. Suit against defendants in their individual capacity for state law torts is barred, and these claims should be dismissed under Texas Civil 101.106F. So you know what? We might actually look that up. Give me 1 second here. Let's just pull that up. Okay, basics of 106. So they are claiming it under F. It could have been brought under this chapter against the suit is considered to be against the employee in the official capacity on the employee's motion. The suit against the employee shall be dismissed unless the plaintiff files amended pleadings dismissing the employee and naming the governmental unit as defendant on or before the 30th. Now this is for a state claim, okay? So if you were to sue them in the state law has cannot override federal law, okay? Federal law says you cannot violate somebody's rights, constitutional rights under 1983. They have the rights to sue you. This says that if you sue a cop in state court for something in their official capacity, they can ask that it be dismissed, and it can be in state law. But for the purpose of this lawsuit, it does not have to follow state law, because this is a federal claim under your federal constitutional rights. So that's stupid. That's a stupid argument. I don't get how that argument. Okay, they'll claim anything. Again, they're trying to claim qualified immunity, so whatever. Plead the requirements and limitations of the Texas Tort Claims Act. This is federal law. Doesn't apply. The exemplary and punitive damages are not recoverable against defendants. Plead any appropriate requirements for their recovery of punitive damages and applicable damage caps. He is not entitled to any relief in this cause. By John Mark Hogg, attorney at law for the defense and certified for service So I just realized, let me see if I can find the original. Give me a second here, you guys. I'm going to try to find the original complaint here. Because I just realized that the city didn't respond. So I'm trying to find out. I thought that this was versus San Angelo. Okay, so that was the I've got a lot. I should have renamed these as I download them, because I've got a lot of PDFs here of these. Let me pause this. I'll be right back. Okay, so I guess my recollection was wrong here. He did not sue the city, which he should have done for failure to supervise. He should have included them in there, and I would expect a amended complaint to include them. For failure to train, for failure to supervise, because that's where the money is at. Suing the individual officers, there's no money there. Now, because there's no money there, don't include the city. Take it to trial and make these cops admit that they were wrong. They're not going to get any money. Cops aren't required to have insurance to protect themselves against lawsuits that are good. So, that should be the case. But it's not. So, he is suing them in their individual capacities and in their official capacities, but he is not suing the city. So, now I understand why the city didn't respond. He could have sued the city, and he probably should have. But anyway, let's look at case law. Let's close that and capture that. Okay, so this is Brown versus Texas. I want you to look at this date, 1979. 1979. This went to the Supreme Court, okay? This is a Supreme Court case in 1979. While cruising near noon in a patrol car, observed appellant and another man walking away from one another in an alley in an area with a high incidence of drug traffic. They stopped and asked appellant to identify himself and explain what he was doing. One officer testified that he stopped appellant because the situation looked suspicious and we had never seen that subject in the area before. They did not claim suspect appellant of any specific misconduct, nor did they have reason to believe that he was armed. When appellant refused to identify himself, he was arrested for violation of Texas statute, which makes it a criminal act for a person to refuse to give his name and address to an officer who has lawfully stopped him and requested the information. Okay? So they're talking about appellant's motion to set aside information charging him with violation of the statute on ground that statute violated the fourth was denied, and he was convicted and fined. The application of the Texas statute to detain appellant and require him to identify himself violated the Fourth Amendment because the officers lacked any reasonable suspicion to believe appellant was engaged in criminal conduct. Detaining appellant required him to identify himself, constituted a seizure of his person, subject to the requirement of the Fourth Amendment that seizure be reasonable. Okay, was it reasonable? The Fourth Amendment requires that such a seizure be based on specific objective facts indicating that society's legitimate interest requires such an action, or that seizure be carried out in pursuant to a plan embodying explicit neutral limitations on the conduct of individual officers. Here, the state does not contend that appellant was stopped pursuant to a practice embodying neutral criteria, and the officer's actions were not justified on the grounds that they had a reasonable suspicion based on objective facts that he was involved in criminal activities. Absent any basis for suspecting appellant of misconduct, the balance between the public interest in crime prevention and appellant's right to personal security and privacy tilts in favor of freedom from police interference, and it was reversed. This appeal presents question whether appellant was validly convicted for refusing to comply with the policeman's rights. So, 1979, you need probable cause for the detention, right? And to ID. So here, they continue on. Failure to identify as a witness. Okay. We need not decide whether an individual may be punished for refusing to identify him in the context of a lawful investigatory stop which satisfy Fourth Amendment. The county judge who convicted appellant was troubled by this question as shown, set out in appendix to this. This situation is to be distinguished from the observations of a trained, experienced officer who is able to perceive an articulate meaning in given conduct. So, 1979, you cannot arrest somebody for failure to ID just because of that, if you have no other suspicion of a crime. Reasonable, articulable, objectable suspicion. Okay. So how long have they been at notice? At least since 1979. I brought this one up because this is a Texas-specific case. There are others. There were others before this, and there have been others after this at the Supreme Court. All right. Texas Court of Appeals, 3rd District at Austin. So this will be, this is inside their appeals jurisdiction of San Angelo District. Okay. And this will be, okay, we'll figure out the date here in a minute because it's not obvious. Hayes filed suit against Dutton alleging the violations of her federal constitutional rights. She asserted that in 2002, Dutton wrongfully arrested her using excessive force. So this one is more on point. Excessive force and causing her severe bodily injury in the process. That is what Mr. Miller alleges. That they slammed him against the cooler. They used excessive force while arresting him. That he was not being... he was not resisting, however, they were treating him as if he was. Dutton moved for summary judgment under both the no evidence and traditional standards, asserting he was shielded by qualified immunity as a police officer. He asserted that Hayes had to overcome his assertion of qualified immunity by proving that he violated her clearly established rights and acted unreasonably or in bad faith in doing so. The parties attached as evidence to the motion for summary judgment in response to the motion, Dutton's affidavit. Dutton said that on that date in 2002, he responded to a complaint lodged against Hayes by her neighbors who alleged she had sprayed them with water while they were in their yard. So sprayed them with water. Okay? On purpose. We don't know. It doesn't go into details of how this happened. We don't know if they were in the middle of a fight while she was watering her grass, so she turned the hose on them, or if she was watering her grass and she accidentally sprayed them. We don't know any of that, but I'm going to assume that it was in anger. Okay? Let's just pretend it was in anger because, you know, that's how it is. Dutton spoke to Hayes, who denied purposely spraying her neighbors. Asked for her name and date of birth, but she refused to give her birth date. Testified at the time he believed she was required to, by law, to tell him her birth date, although he admits he now realizes she did not violate any laws by refusing to do so. So, his thinking of what the law is and what the law actually is important. Dutton said he told Hayes that she could be arrested for failure to identify for herself, at which point she began to walk away. Dutton grabbed her arm and twisted it behind her back to stop her from leaving and to effect an arrest for failure to identify. An arrest for failure to identify. When he grabbed Hayes, she began spinning around in circles, pushing and slapping at my hands, at which time I decided to place handcuffs on her. Now, you make an illegal arrest. You try to arrest me illegally, I may also fight back. I don't care what the law says. You try to arrest me illegally, there's going to be problems. But this is what he alleges. We'll talk about what she alleges here in a minute. Dutton then pushed her against her parked car to prevent her from moving and testified that while he tried to pin her, she turned and tried to strike him. After he handcuffed her and started placing her in his patrol car, she told him she had limited range of motion in her legs and refused to put her legs in the car. He averred that after several requests, he physically placed her legs in a car as gently as possible. He stated that Hayes did not complain about any pain or request medical attention. He said that when he first grabbed her arm and twisted it behind her back, she said no and may have cried, but he did not recall whether she walked with a limp or told him her arms could not bend in certain ways. He concluded his affidavit by stating pinning Hayes against the car was a procedure he was taught at the police academy, and he believed he used reasonable force. He was not aware at the time that Hayes had any physical disabilities, and he had never had any complaints for excessive force lodged against him in the past. Hayes described a very different version of events and testified that Dutton acted irritated with having been called out to address the neighbors, spat, and very forcefully asked for her name. She said she asked why he needed her name, and he jumped at her, demanded her name and date of birth. She started to ask him why he needed her birth date, and Dutton lunged at her, grabbed her arm, and twisted as hard as he could behind her back. He does admit that he learned that she has disabilities. Okay, now. She denied walking away, resisting arrest, or attempting to strike him, and said she twisted her body because Dutton was twisting her arm and she was trying to maintain her balance. She testified that she screamed and cried when he twisted her arm behind her, telling him that her arm did not bend that way, and that told her he was going to make it twist. Hayes testified that when she asked why he was doing this to her, he said, "Because I can," and he told me to shut up or I'm going to add more charges. She asked what charges he already had. He said, "I don't know, I'll think of it as I go." Hayes testified that her knees started to buckle and Dutton threw her against her car, and then with the assistance of another police officer, handcuffed her, pushed her towards the police car. Testified that she heard her right wrist snap when he wrenched it behind her back to her handcuff her. When Dutton told her to get into the police patrol car, she told him she could not maneuver into the space because she has limited range of motion in her knees. Told her that if she did not put her legs in the car, he would make them, and then he and the other officer stuffed her into the back of the car, twisting and pushing her knees to force her into the car. Hayes testified that she was hyperventilating and crying because of the pain, and Dutton again told her that if she didn't shut up, he was going to add on more charges. After she was released, she sought medical attention for bruises on her arms and knees, spasms in her left arm, and fractured right wrist. She testified that Dutton bruised her arm when he grabbed her, that her knees were bruised from being thrown against her car and being forced into the patrol car, and that she still has knee problems due to Dutton's forcing her into the car. A government official performing discretionary functions is entitled to qualified immunity unless his conduct violates clearly established statutory or constitutional rights of which a reasonable person would have known. Where are we at? We're at 30 minutes. Okay, I'll try to get to this. Bush versus Strain, 2008. As in all summary judgment cases, we view the facts in the light most favorable to the non-movement, indulging all presumptions, resolving any doubts, and taking as true evidence in her favor. So Hayes' favor. They have to read everything as true from her fact, what she says. In a suit against an officer for alleged violation of constitutional right, the requisites of qualified immunity defense must be considered in proper sequence. We first ask if the alleged facts viewed in plaintiff's favor show that the officer's conduct violated the plaintiff's constitutional rights. If so, we then ask whether the right was clearly established and whether it would be clear to a reasonable officer that his conduct was unlawful in the situation he confronted. If the law did not put the officer on notice that his conduct would be clearly unlawful, summary judgment based on qualified immunity is appropriate. We cannot apply current law to the first step and the law at the time of the incident to the second step. Hayes alleges that Dutton violated her right to be free from unlawful arrest and from the excessive use of force. Those are distinct claims, must be analyzed separately. We apply federal law to our inquiry. So again, with Miller, they are trying to take state law of we can't be sued because they are suing me, the individual. No. Plaintiffs have a clearly established constitutional rights to be free from arrest, absent an arrest warrant or probable cause. That is a fundamental right. That is probable cause or a warrant. And probable cause is a semi-low bar to reach. So, an officer has probable cause to arrest in light of clearly established law. The facts and circumstances known to the officer at the time of the arrest would allow a reasonable person to conclude that the suspect had committed or was committing an offense. An officer is protected by the first prong of qualified immunity if at the time of the arrest the law is unsettled as to whether the suspect's conduct constitutes an offense. So, is it against the law in Texas for somebody to not identify themselves? No. Was that clearly established? Yes. Clearly established. Oh, wait, you're going to probably talk about that. The threshold question then is whether, considering the allegations in the light most favorable to Hayes, Dutton violated Hayes' right to be free of a warrantless arrest not supported by a probable cause. It is also uncontested the officers did not have a warrant to arrest her. Their warrantless arrest of Fogarty therefore violates the Fourth Amendment unless that arrest was supported by probable cause. Dutton admits that at the time he grabbed Hayes' arm, initiating the detention and arrest, she had not committed the offense of failure to ID. Okay? So she did not commit a crime. In his brief, he does not dispute that Hayes had the right to be free from arrest, absent probable cause, asserting only that he was mistaken about whether her conduct was a violation of the law. So he thought. So the Supreme Court ruled that us as ordinary citizens, and this is what still pisses me off about this qualified immunity. Sorry, I know we are running long here. We're at 33 minutes. As ordinary citizens, we are expected to know every possible law out there, and if we are in violation of it. We have to know all of them. And ignorance of the law is no excuse. Ignorance of the law is no excuse. So then, why is it that cops are allowed to be ignorant of the law? Stupid dog. Why are cops allowed to be ignorant of the law? If the law says that you cannot be arrested for failure to ID, why are cops allowed to say, oh, I didn't know that? And it has to be established by a court of law that you can't violate that in order for them to be sued. Ignorance of the law is no excuse for us, but it is an excuse for those who are supposed to uphold the law. That is my biggest, absolute problem with qualified immunity, is the clearly established part. Okay, but he instead concentrates on arguing that she cannot show that he acted unreasonably in making the arrest. We hold that Hayes satisfied the first prong of the test and turned to the second prong of the qualified immunity inquiry. Protects officers who reasonably but mistakenly violate plaintiff's constitutional rights. If a reasonable officer would have believed that his conduct confirmed constitutional standards based on information available to him and clearly established law. Excuse me. Because Hayes alleged a violation of her constitutional rights to be free from arrest without warrant or probable cause, We next ask whether under the circumstances the right was clearly established. We ask whether it would be clear, in Saucier, we ask whether it would be clear to a reasonable officer that his conduct was unlawful in the situation he confronted. Freeman. In other words, the contours of the right must be sufficiently clear that a reasonable official would understand that what he is doing violates that right. Anderson, 1987. The central concept is that of fair warning. The law can be clearly established despite notable factual distinctions between the precedents relied on and the cases then before the court, so long as the prior decisions gave reasonable warning the conduct then at issue violated constitutional rights. Fifth Circuit, 2004. En banc. Quoting Hope versus Pelzer, 2002. Taking the facts in the light most favorable to Hayes, the record shows that Dutton began to effect an arrest when Hayes refused to provide her birth date. Let's go ahead. Let's read these here. For Freeman versus Gore, the court noted that both the probable cause inquiry and the second prong of qualified immunity, asking whether a mistake was reasonable, are framed in terms of how a reasonable person would act. The court held that a finding that the officers lacked probable cause, which requires a reasonable person inquiry, does not foreclose the possibility that they may be entitled to qualified immunity. Dutton asserts that failure to ID was not the sole basis for the arrest, and that he did not decide to arrest Hayes until she tried to walk away and slapped at him. However, we read the facts in the light most favorable to Hayes, who alleged that Dutton grabbed her arm and pushed her against a car, telling her that he would think of a charge against her when she started to ask why he needed her birth date. Further, at the hearing on Hayes' criminal case, Dutton agreed when asked, when you attempted to arrest Miss Pupko, your only basis at that point was for failing to ID. Is that correct? Okay, so that does not continue down below. The law on failure to ID was not at the time unsettled or in flux. Nope, clearly established. And Dutton admitted later that he was mistaken in his belief that her refusal to provide her birth date was a criminal offense. See Texas Penal Code 3802. Person commits an offense for failure to identify if she refuses to provide identifying information to an officer who has lawfully arrested the person and requested the information. That is what the law says. You cannot be under arrest for failure to ID if the only charge against you is failure to ID. Or if she provides false information to an officer who has lawfully arrested or detained her, or is good to cause to believe she witnessed an offense. So don't give a false name. Even if you say John Doe, that's a false name, okay? Thus, Dutton was not mistaken about the application of clearly established law to the facts and circumstances as he believed them to be. Instead, Dutton made a mistake of law in believing that Hayes' conduct, as he perceived it, amounted to an offense. Qualified immunity did not protect Freeman. Did not protect an officer as a matter of law when plaintiff's refusal to allow police to enter her home without warrant did not give rise to probable cause to arrest for interference with public duties or hindering arrest. Peterson versus Gibson. Order denying motion to dismiss, not entitled to summary judgment and qualified immunity when plaintiff's conduct as known to officers did not amount to theft of services. In Humphrey, qualified immunity applied because law about disorderly conduct was unsettled. In Moore, qualified immunity applied because law regarding warrantless entry into home was unsettled. So, this is not unsettled law. Those are some unsettled law and some are not. Qualified immunity protects an officer who is reasonably mistaken about the facts as they actually exist in light of the established law at the time. Keeping in mind that police officers must make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving, that we should view facts with some deference to the officer's on-scene perspective. Under the established law, no reasonable officer could have believed that there was probable cause to arrest Hayes for her failure to provide her birth date, and a reasonable officer would have recognized that her conduct did not justify an arrest or create probable cause. In Freeman, a reasonable law enforcement officer faced with these circumstances would have known he could not enter the home and arrest Basher without a warrant, exigent circumstances, or consent. That doing so would offend the Fourth Amendment was clearly established by the precedent recounted above. In Peterson, they say any reasonable officer who's spent as much time with the parties as Officer Gibson would realize that Peterson lacked criminal intent in light of Illinois law defining theft of services. Because Dutton did not establish as a matter of law either the prongs of his qualified immunity defense, the trial court did not err in denying his motion for summary judgment on Hayes' claim of unlawful arrest. And that is exactly what I expect to happen with Miller. It's clearly established that you cannot be arrested for not IDing yourself. Okay. Excessive force claims. Having held that Dutton lacked probable cause does not, however, end the inquiry into whether qualified immunity protects him from his excessive force claim. Whether Hayes may proceed with her excessive force claim is independent of whether Dutton had the power to arrest her. Now, here I disagree. If you did not have probable cause to arrest somebody, anything that happened to that person as a result of your arresting them is illegal, is excessive. Even if they broke a fingernail, okay? If they broke a fingernail, that's excessive force. If they got a little bruise on their arm from your arrest, that's excessive force because the arrest was not legal. If it's an illegal arrest, it's an illegal arrest, and anything that came after that is bad. Okay. Whether Hayes may proceed with her excessive force claim is independent. Where was paragraph, or where is note 5 at? Oh, 5 up here. So, this case is similar to Freeman, in which the police sought to serve an arrest warrant on the plaintiff's son. He was not home, so they went to Freeman's house and asked to search him there. She said she could not enter without a warrant for her address, so the police arrested her for hindering apprehension and interference with police public duties. The court held that Freeman's refusal to allow the police to enter without a warrant did not give rise to probable cause because the officers were not performing a duty or exercising authority imposed or granted by law. Her behavior did not amount to hindering arrest. So, to arrest somebody with a warrant, they could enter your home. So if they're trying to arrest you, they can probably enter your home to effect that arrest. That might require a search warrant. Okay. Questionable. Okay? Let's not argue that fact. But he wasn't home, so they went to his mom's house. And she said, nope, you can't come in here to look for him. He's not here. You can't come in. That's basically what that case was saying. Interfering with public duties. The court held that a reasonable officer would have known that he could not lawfully search Freeman's home and that Freeman was not, therefore, interfering with any exercise of any authority granted by deputies at law. Okay, so that was what the footnote was for. Fourth Amendment bar on excessive force. If she alleges an injury caused by the officer's use of force that was excessive to the need and that the use of force was objectively unreasonable. Minor incidental injuries that occur in connection with the use of handcuffs will not support a claim for excessive force. Again, I've got to disagree with that. I have to disagree with that. Because if you had no probable cause to arrest somebody, if they are injured as a result of that, that is excessive force. I don't care why you used that excessive force. I don't care what force was used. Any force is excessive when you were doing so illegally. And that is what the law should be. The injury suffered must be more than de minimis, more than minor. Versus Bomber. Similar to the facts presented in Bush, Hayes alleged that Dutton grabbed and twisted her arm, pinned her against the car, and forced her legs into his patrol car, in the process fracturing her right wrist, bruising her knees, leaving bruises on her arm from his fingers, and causing spasms in her left arm. She was arrested after she interfered with questioning. First of all, Hayes alleged that Dutton lunged at her and twisted her arm behind her back before he could finish asking why he wanted her birth date, that she did not attempt to walk away or resist his use of force, and that he continued to use painful force even after she told him her arm and knees could not bend in the ways he was forcing them. Considering the facts as alleged by Hayes, she was being questioned about a minor incident, posed no risk of danger to Dutton or anyone else, and was not attempting to flee or resist arrest when he grabbed her arm and threw her against the car. Yeah, so thus we hold that there's evidence that Hayes suffered substantial injuries as a direct and sole result of Dutton's use of excessive to the need and objectively unreasonable under the circumstances. Satisfied the first prong of the inquiry. We next ask whether Dutton's use of force in violation of the Fourth Amendment was nevertheless objectively reasonable in light of clearly established law at the time. To show that his conduct was objectively unreasonable, we ask whether Hayes' right to be free from the degree of force used by Dutton was clear to a reasonable officer at the scene, considering the specific circumstances which evolve quickly and require officers to make split-second decisions about the necessary amount of force. The right to arrest someone necessarily carries with it the right to use some degree of physical coercion or threat thereof to effect it, and in the allowable degree of force depends on the severity of the crime, whether the suspect posed an immediate threat to the officer's safety, and whether the suspect was attempting to flee or resist arrest. So screw you, suspect. Screw you, officer. Okay. But what degree is okay? The alleged crime for which Hayes was being arrested, failure to identify, is a minor offense. The facts as alleged do not show that Dutton had any reason to believe that Hayes posed an immediate danger to his safety, and she was not attempting to flee or resist arrest when Dutton grabbed her. Dutton did not ask or order Hayes to stay where she was, say that he was not finished talking to her, or verbally tell her that she was under arrest. Instead, he seized her arm, leaving bruises where he grabbed her, and twisted it behind her back. We hold that in light of the circumstances and the offense for which Hayes was arrested, a reasonable officer wouldn't have known that he could not apply the force that Hayes alleged was used, force that she alleged resulted in visible bruises, ongoing knee problems, spasms in one knee, arm, and a broken wrist in the other. Dutton has not shown as a matter of law that he is entitled to qualified immunity on her claim of excessive force. So, again, Mr. Miller states that they injured him when they threw him up against the freezer. It took 3 of them. Now, why it took 3 of them, let's not argue semantics here. It took 3 of them, and it looked like a pretty violent push, and his neck was up against it. You can see that in the video. His neck is up against the fridge, or the cooler, whatever it is. Right? So he's like this, with that against his neck. And you can see that very clearly. Is that excessive? That's for the court to decide. But again, to me, any force when none was lawfully allowed is bad. Should be against the law. Dutton did not establish his right to judgment as a matter of law in his assertion of qualified immunity to Hayes' claim of unlawful arrest and excessive force. Therefore, the trial court did not err in denying his motion for summary judgment. We affirm the trial court's order. So here, the trial court denied qualified immunity. That's exactly what I expect to happen here in Jack Miller versus stupid officers for their illegal arrest in Walmart. They're not going to get qualified immunity. The case law is clear on this. So, looking forward to finding out what happens next. There's going to be more. There's going to be a response from Mr. Miller, at least, on what is stated in their claims, and then probably a hearing of some sort. So I'll try to find out when that hearing is scheduled, and I'll try to attend it via online and see what happens. So thank you guys for joining me. Hope you stuck around. Have a great day.